morning. I'm Erik Walker, Vice President of Justinian and Associates, and I'm here again today to talk to you about some area of the law that we think will be of interest to you. Our firm specializes in pharmaceutical litigation, other kinds of personal injury lawsuits, and immigration law. Today we're going to discuss pharmaceutical litigation in particular. Pharmaceutical litigation is very different than other types of personal injury lawsuits. The elements of the claims that the plaintiff raises in a pharmaceutical case are distinct, and that's what we're going to focus on today. And I want to begin by talking about the kinds of claims that you can make in a pharmaceutical case. In particular, strict liability versus negligence claims. In any personal injury suit, you can allege negligence. Negligence just means that the defendant failed to act as a reasonable person would. In particular, negligence is the failure to act as an ordinarily prudent person would facing the same or similar circumstances. So, for instance, if you're a driver on the road and you run a stop sign, you were negligent. If you're a doctor who fails to meet the standard of care for professionals in your field, you were negligent. Negligence means engaging in unreasonable conduct. And in a typical personal injury lawsuit, negligence is the principal claim that is raised. But in a pharmaceutical case, you can also raise what's called a strict liability claim. Strict liability does not require any proof of unreasonable conduct on the part of the defendant. Strict liability is essentially liability without fault. Now, you might ask, why would we hold companies liable if they didn't do anything unreasonable? And the answer is fairly simple. If someone is injured by a dangerous product, someone has to be accountable for that. The question is, who is going to pay for the injuries that were caused? Is the individual who was injured going to pay for their own injuries, even though it was caused by somebody else's product? Is society at large, taxpayers, supposed to pay for that damage? Or is the company that makes the product, sells the product, and profits from the product the entity that should pay? And as a society, we have decided that it is the company that is making money from the product that ought to pay when that product causes injuries, even though there may be no fault or no unreasonable conduct by that company. And so we have what's called strict liability in pharmaceutical cases. And there are essentially three kinds of causes of action or claims that a plaintiff can make under the strict liability doctrine in a pharmaceutical case. They are design defect, manufacturing defect, and marketing defect. A design defect claim essentially says that the product was defectively made or designed. In other words, the plans for the product, the scheme for the product, the decision of what to do to make the product was defective. So if you have a drug that has a dangerous component, that's a design defect. If you have any kind of product where too much of one ingredient is planned in the product, that's a design defect. If you have a drug that is just deadly and should never have been made in the first place, that's a design defect. A design defect says that the plans for the original product were bad. A manufacturing defect says the plans for the product were okay. The design was fine, but the actual making of the product did not conform to specifications. So you may have a product that is perfectly safe if made properly, but in the factory, somehow or another, something happens and too much of one ingredient gets put in the product, or some defect occurs during the making of the product. That's a manufacturing defect. The third kind of claim is a marketing defect, and that simply means failure to adequately warn. There are going to be pharmaceutical products that have risks. There's no question about that. And there's no way to avoid those risks. But at the very least, manufacturers have to warn potential consumers about those risks so patients can make an informed decision as to whether to take the product. Failure to adequately warn individuals about the risks of a product is called a marketing defect. These are essentially the three causes of action that you can claim under the strict liability doctrine. Now, you can also claim negligence for these claims too. You can claim that the design defect, the defect in the planning of how the product should be made, was unreasonable. Same for marketing defect and manufacturing defect. But you don't have to. You can argue simply that these defects existed and the manufacturer is liable for them, even if the manufacturer didn't do anything wrong. There are other claims, of course: fraud, breach of warranty, breach of consumer protection statutes, that are the kinds of claims you can make in many different types of torts. But we're going to focus on these causes of action that are unique to pharmaceutical litigation. Principally in pharmaceutical cases, we focus on design defect and marketing defect. I have seen some cases where there was a manufacturing defect. I remember one litigation in particular where the drug was simply made at a factory that had very poor safety standards, and literally the deadly component of the drug was multiplied by many times during the manufacturing process, and as a result, people died. But generally speaking, the claims that we focus on are design defect and marketing defect or failure to warn. The plaintiff argues either that the product is just dangerous as it is, as it's designed, or that the manufacturer failed to adequately warn of the dangers of the product, and as a result, the plaintiff was injured. Now, once the plaintiff establishes one of these claims or causes of action, there are various defenses that the defendant can raise, the manufacturer can raise, to the claims. One is called the state-of-the-art defense. This is typically raised against the design defect claim, and it says this: we produced our product based on existing knowledge of the time, and we conformed to what everyone knew the risks of products were at the time. In other words, we made our product just like everybody else did. We did nothing wrong. We did everything right. The problem with the state-of-the-art defense is that it really takes the design defect claim out of the strict liability realm and puts it into the negligence realm. One of the reasons we have strict liability, as I mentioned earlier, is because manufacturers are the ones who profit from their own products, and therefore when someone is injured by a product, and we have to decide who to hold accountable, the manufacturer, the injured individual, or the taxpayer, who should pay for those injuries, it's the company that makes the product and profits from it that should pay for the injuries, even if the company did nothing wrong. This state-of-the-art defense essentially says we did nothing wrong, which contradicts the whole premise of strict liability. So a number of states reject the state-of-the-art defense. They have something called the hindsight claim, which says that we look in hindsight at what the dangers or risks of the product are. We don't look at the knowledge of the time. And if a court is being true to the principle of strict liability, it will reject the state-of-the-art defense because it is a negligence principle. It asks the question of whether the manufacturer did anything wrong. It doesn't suggest that the manufacturer should be liable for a design that ultimately injured people. But there are a number of different state courts in different states that do recognize the state-of-the-art defense and will allow the manufacturer to say, we made our product to conform to existing scientific knowledge, and we did not in any way deviate from what the knowledge of the time was regarding risks, and therefore we should not be held accountable. A second defense is called the learned intermediary defense. And this argument is essentially this. Prescription drugs are very complicated. They're very complex products. And the decision of whether to ingest the products are decisions that should be made between patient and doctor. The manufacturer shouldn't be interjecting itself in that decision. So what most states recognize is that the duty of a manufacturer to warn in a marketing defect claim, failure to warn, the manufacturer's duty to warn extends only to the doctor, the learned intermediary, who would be the doctor. In other words, the manufacturer in a prescription drug case does not have a duty to warn the patient directly. The manufacturer's duty is limited to warning the doctor. It is then up to the doctor to transfer the warnings or communicate the warnings to the patient, and the doctor and the patient together will make the decision of whether to use the drug. This is an important defense because it means that the plaintiff has to prove that the manufacturer failed to adequately warn the doctor in the physician's desk reference, or any other materials that are provided to the doctor. And the plaintiff then has to prove that if the manufacturer had provided adequate warnings to the doctor would not have prescribed the product to the patient. There are many instances when doctors say, even if that warning had been stronger, I would have prescribed the product. And that's why this defense is a very potent one for the defendants. And we're going to talk about it a little bit more later on. There's also a statute of limitations defense. This essentially is a claim that the plaintiff failed to file their suit on time. There are deadlines for filing lawsuits in states throughout the country, and they vary from state to state. If the plaintiff fails to file their lawsuit within a certain period of time, the lawsuit is barred under the doctrine of the statute of limitations. The good news is that most states in the country have something called a discovery rule. The discovery rule is an exception to the statute of limitations, and it says this: even though the deadline for filing suit may be 2 years, that deadline doesn't start at the time the person used the drug, or even at the time the person necessarily was injured by the drug. It starts at the time the person knew or should have known that the drug caused their injury. So for instance, if someone ingests a product in the year 1979 and they develop an injury in the year 1985 and they file suit in the year 1987, their suit is timely, even though it was filed far more than 2 years after they took the drug, because they filed it within 2 years of being injured. Or if you have a situation where someone is injured, let's say in the year 2015, and they don't file suit until the year 2019 because they don't learn that the drug caused their injury until the year 2017. And I'm sorry about all the dates here. The lawsuit is timely. The key inquiry is, did the plaintiff file his or her lawsuit within the time period, the limit provided by law, based on when they discovered that the product caused their injury? Did they file their lawsuit within the time limit based on when they knew or should have known that the drug caused their injury? And so there's a good defense to the statute of limitations that plaintiffs have. There's another defense called fraudulent concealment. If the plaintiff can prove that the defendant fraudulently concealed the plaintiff's cause of action or claim, then the statute of limitations does not apply. The problem with the fraudulent concealment claim, and it is a claim that is misinterpreted by many plaintiff lawyers, is we're not talking about plain vanilla fraud here, where that the defendant concealed the risks of its product. We're talking about a defendant actively concealing from the plaintiff the fact that the plaintiff has a cause of action. So you have to actually prove that the defendant caused a particular plaintiff not to know about their claim through fraudulent conduct, and that's very difficult to prove. The best defense for a plaintiff to statute of limitations is the discovery rule, to argue that the plaintiff had no reason to know of the cause of his or her injury within the time period prescribed by law. Another defense is the unavoidably unsafe products defense. There's a doctrine in the law that says that there are certain products that are unavoidably unsafe. And if a product cannot be made any safer than it already is, the only thing the defendant has to do is to provide adequate warnings. So you don't have a design defect claim if there's an unavoidably unsafe product, so long as the defendant adequately warns about this unsafe product. This doctrine has only been adopted by a few states in the country and is generally limited to life-saving products like vaccines, products that are really essential to public health, not just your garden variety drug that might be necessary to relieve some kind of suffering or ailment. Finally, there's the clear evidence preemption defense. There has been long argued in the law a position that claims against drug companies are preempted by federal law. What that means is that because there are FDA regulations of drugs, and because the federal government has a regulatory scheme for drugs, any claims that plaintiffs may try to raise under state law, any kind of strict liability or negligence claims, are barred or preempted by federal law. In other words, they would interfere with the operation of federal law and therefore are not allowed. In 2009, the United States Supreme Court ruled that the preemption doctrine in general, as applied to pharmaceutical products, does not exist. That while there is an FDA regulatory scheme, they're minimum standards. They're not designed to be the be-all, end-all of regulating drug companies. And that the litigation of state tort claims provides an additional protection for the public. It doesn't interfere with the operation of federal law. And therefore, there's no preemption. But there is an exception if, under clear evidence, if the FDA actually considered stronger warnings, like the warnings the plaintiff proposed, and rejected those warnings, then a claim that the drug company should have provided those warnings is deemed preempted. And that's called the clear evidence preemption doctrine. There are strong arguments against the clear evidence preemption doctrine. For one thing, the FDA has to actually have rejected the particular warnings the plaintiff proposed. There can't be a situation where the FDA simply said, we don't like this warning being proposed, we're going to reject it, and therefore any warning that the plaintiff proposes is preempted. The FDA has to have actually rejected the particular warning being proposed by the plaintiff for the clear evidence preemption doctrine to apply. In addition, many courts have held that it's not enough for a drug company to simply propose a stronger warning. We believe the warning should have said X, and the FDA says, well, we reject that, and therefore there's preemption. The drug company has to actually urge and press the FDA to accept the warning. And the reason for that is that otherwise what was happening is drug companies were simply sending a letter to the FDA saying, here's a warning, why don't you adopt this? Without really urging it or trying to persuade the FDA. Without any evidence, the FDA would say, no, we're not going to adopt that. And then when the plaintiff argued that warning should have been adopted, the drug companies would assert preemption. And the courts have said, no, you have to go beyond just proposing a warning to the FDA to assert clear evidence preemption. You have to actually urge the FDA to accept the warning, provide reasons why the FDA should do so, and only if the FDA rejects those reasons will there be clear evidence preemption. So these are essentially the causes of action and the defenses to those causes of action that are raised in pharmaceutical litigation.